Welcome to the National Crime Victim Law Institute's online toolkit. Toolkits, which include a combination of videos, downloadable resources, and other interactive exercises, are part of the larger universe of resources that NCVLI offers. In addition to these toolkit resources, you can visit NCVLI's website at www.ncvli.org to access additional free resources, including a number of in-depth articles in NCVLI's Victim Law Library. You can also visit our website to request additional technical assistance and trainings on victims' rights-related topics.
Victim impact statements are one aspect of victims' broader right to be heard, which applies in different ways at different stages of the criminal justice process. The most common context for victim impact statements is in connection with sentencing proceedings after a defendant has been found guilty or has entered a guilty plea. Victims' right to be heard by giving an impact statement is a fairly universally recognized part of state and federal criminal justice systems. Depending on the jurisdiction, the right to be heard can be found as a state constitutional right or as a state or federal statutory right. This right may also be mentioned in the rules adopted by the different jurisdictions. Even apart from explicit laws guaranteeing victims the right to be heard and to give impact statements, judges have long had the discretion to hear from a broad range of individuals in connection with sentencing proceedings. Victim impact statements, which give survivors an opportunity to talk about the crime and the impact it's had on them, are different from victim impact evidence, which is testimony that's given by the victim under oath during the sentencing phase of a case, often in death penalty cases. In the vast majority of places, victims are not required to provide victim impact statements under oath. Also, in most jurisdictions, defendants are not given the opportunity to cross-examine victims about their statements, though this could happen in some cases, depending on the jurisdiction. Defendants may have a chance to provide information of their own if the victim impact statement includes facts about the crime that are not part of the record in the case. Because the scope of this right and how it's implemented varies from jurisdiction to jurisdiction, it's important to know the law in your jurisdiction, as well as be familiar with the case law explaining how the law might be applied. Victim impact statements serve a number of different and interrelated purposes. They allow survivors a unique opportunity to provide information to the sentencing body, which is usually a judge, but in some jurisdictions and in some cases could be a jury. This may be the only chance many victims have to explain the impact of what they experienced in their own words and in a way that works best for them. Because of this, victim impact statements are often beneficial and empowering moments for those who choose to exercise this right, even though some survivors may find giving the statement to be difficult. Victim impact statements also provide an opportunity for survivors to describe the harm caused by the crime in the presence of the defendant, which, in addition to physical and emotional impacts, may also include discussion of the financial consequences of defendant's conduct. Survivors often have questions when it comes to victim impact statements, and we have invited a panel of 4 practitioners to join NCVLI in discussing this important subject. Throughout the remainder of this session, we will play video clips featuring Mary Wallace, Russell Butler, Helen O'Brien, and Bridget Harwood that were originally recorded in 2014 in their roles at the time. Each of these practitioners will share experience and advice, both from an advocate perspective and an attorney perspective, providing practical tips for working with survivors in the context of addressing victim impact statements. So what are some common concerns and questions that survivors have when it comes to victim impact statements?
Well, I want to know, what's a victim impact statement?
What they're allowed to say.
Can they use pictures?
I want to be heard, but I don't necessarily want to have to see the defendant.
They're very often concerned that they're going to cry and that they're not going to get through it.
They really want to know the mechanics and the whys of victim impact statements so they can decide if they're going to do one and what should be included.
When it comes to the mechanics of victim impact statements, jurisdictions around the country vary, both in terms of what may be included and when and how the statements are made. When it comes to timing, the vast majority of jurisdictions guarantee victims the right to give an impact statement before sentence is imposed, generally in connection with the defendant's sentencing hearing. Because the specifics vary from jurisdiction to jurisdiction, practitioners should make sure they know and understand the laws and practices that apply to victim impact statements. Survivors will often ask questions about many of these details, so it's important to understand how victim impact statements work in your jurisdiction so you can explain the process clearly and answer any additional questions that could come up. Recognizing the differences that exist across the country, why are victim impact statements important to the criminal justice process?
And not that folks need a reminder, but I think it's a very good reminder that there is an actual human being that was directly affected by the crime.
They get to have a voice. They finally get to have a moment where they get to tell the judge and the defendant what happened to them and how it's made them feel. It's very important.
Victim impact statements may be given in a number of different ways, depending on the jurisdiction. One of the most commonly exercised options is for survivors to give an impact statement in person in the courtroom. Instead of speaking themselves, a victim may choose to ask a representative to read their impact statement for them. Victim impact statements may also be submitted in writing. Written victim impact statements are generally separate from victim input that may be included in a pre-sentence investigation report, even when a victim is offered the opportunity to submit a statement to the probation officer or other individual who prepares the pre-sentence report. Be aware that in some jurisdictions, victims who choose to submit a written victim impact statement may be required to submit their statement to the prosecutor and the defendant or defense counsel in advance of the sentencing hearing. Technology-assisted statements, which can include recorded audio or videotape statements, may also be options that are available to victims who would prefer to give an impact statement in those ways. Some jurisdictions explicitly provide for victim impact statements to be made in audio-taped or videotaped format, including information stored on a CD, DVD, or another type of electronic recording. Although victim impact statements are always limited in that they cannot be unfairly prejudicial to defendants, sometimes the use of technology-facilitated victim impact statements have come under scrutiny by courts. This often occurs when pre-recorded videos contain a more artistic combination of images, music, and sound, as opposed to a simple recording of the victim reading or otherwise speaking their statement aloud. So be sure to check your jurisdiction's law when working with a victim who would like to utilize an electronic delivery method. Additional options, such as giving a live statement remotely using video conferencing or live streaming technology, or participating by telephone, are also generally available to facilitate the exercise of this right. Regardless of which format is chosen for the impact statement, survivors often feel that the opportunity to give a statement is very important.
Sometimes it's the only time they're going to be heard in the courtroom.
Gives them a voice. It lets their opinion be considered by the judge, the prosecutor, the defendant, the defense counsel.
So for many of them, they literally hang the entire way they assess the criminal justice process on how this day turns out, how well they think they spoke, the ultimate decision of the judge. For them, this is the one time they get to really, truly participate.
Through the process, the defendant is the star of the show, the lawyers are the star, but it's finally where the victim gets to be, front and center talking about it, and that's what it's really all about.
In addition to the central role that victim impact statements can have for many survivors, impact statements can also have an important effect on the victims' rights movement as a whole.
It matters because every time a prosecutor sees a victim that has a very prepared, very thoughtful victim impact statement, we spend a lot of time preparing that with them up front, that really hits in on this thematic theme of how this has impacted my life overall. The court sees that, the other attorneys see that, and they start to see, wow, there's actually a person involved in the criminal justice process that's been harmed, that's been impacted. And if we're there as an attorney representing them, introducing them, I think it really brings a sense of awareness to the fact that there's this huge movement of people supporting victims' rights in the criminal justice system.
When it comes to giving impact statements, it's important to keep in mind that there may be differences between what a victim is permitted to say in death penalty cases as opposed to other types of cases. The United States Supreme Court, in a 1991 case called Payne v. Tennessee, affirmed that the Constitution does not ban victim impact statements. In a footnote to the decision, however, the court introduced some ambiguity regarding whether victim impact statements could constitutionally include sentencing recommendations in capital cases. A number of jurisdictions have held that victim impact statements may not include the victim's views about the appropriate sentence in death penalty cases. If you're working with a survivor in a death penalty case, be sure to know your jurisdiction's law and whether there are any limitations on what a victim can say in their impact statement. Setting aside the issue of sentencing recommendations in capital cases, what might you tell victims who ask for help in figuring out what to include in a victim impact statement?
Use your own words.
How I felt, how I currently feel, and what the future might hold for me.
Ultimately, we almost close every victim impact statement with we rely on the judge to do what's fair in this case, and having known the human element here and the impact on the survivor's life, do what you think is right. And I think really putting the onus on the court makes the victim feel like they're not necessarily demanding something, but they're giving the judge an opportunity to do what's right when they've heard what this crime has really done to their life.
I heard a statement once where they sort of put an onus on the defendant that because they had done this terrible thing, that they now owed the world a better them. They wanted that defendant to go out after they get out of prison and be a better human being than they might otherwise have been, because in fact they owe that to the victim.
A statement doesn't have to be sterile. People are human. The impact of victim impact is hearing it from the victim with emotion. It's okay to have emotion.
I always tell them to focus on the word impact. And I have to do it by the victim when I'm speaking to them, knowing what I know about the case and knowing their personalities. But I stress to them, you think of the word impact. How has this affected your life? Financially, emotionally, and to put all those down. And to get all that in, and it might be the littlest thing to you, but it's huge. It's how it's impacted your life. And I have the smelly feet motto that I very often tell people. And I did a sentencing for a family whose son was murdered, and it was standing room only in the courtroom. Lots and lots of people making statements, and his one sister came up to make her statement, and everybody had done theirs, and she was last. And she said, everybody in this courtroom knows my brother had the most notoriously stinky feet there ever was. And the whole courtroom started laughing because they all knew this kid had stinky feet. It was just his thing, and he had them. And she said, Judge, what I wouldn't give to smell those stinky feet one more time. And everybody just kind of laughed, but it was really huge because we had heard, how many Christmases they were going to miss and this and that, but it was just a little tiny thing about this kid that she would have given anything to have another time around. And it's kind of a silly story, but it's what I try and tell people is get those things in that, the judge may not have heard a dozen times before, or even 100 times before. Get in the stinky feet.
Victims frequently have questions about victim impact statements that go beyond content. What else should they keep in mind when preparing to give a victim impact statement?
This is going to be hard.
I always tell them start early. Don't put it off till the night before. I always tell them you will regret it because it's the hardest thing you'll ever have to do. I usually tell them, if you're a writer, if you have a computer, to start writing and just put it all out there. Just put it out there, and then go backwards from there. Just get it out on paper and go from there.
Ultimately, for attorneys, it's important to know that victim impact statements are not something you do the day before. They take weeks and weeks to truly do something that's really powerful, and ultimately practiced enough that the survivor can get up there and feel like they are prepared to face everything they're going to have to face to have that voice that day.
Survivors may feel daunted by the prospect of drafting a victim impact statement. Victim impact statements are not easy, and even professionals who work in the criminal justice system can struggle when they're in the position to make one.
I spent hours and hours and hours working on it and did it over and over again. And then I got up there in front of the judge and I started to cry. And so luckily I followed my own advice because I made the font really big, and I had a box of Kleenex and I had a backup plan. But I would never tell a victim it's an easy thing to do, because it's not. It's incredibly important. But you'll get through it. Even if it's tears and choking back, and trying to just get through it, you'll get through it.
When working with a victim who's chosen to give a victim impact statement at sentencing, it can be helpful to make sure to discuss that the process of preparing a victim impact statement can be difficult. It can be helpful to start early. If a survivor plans to write out their thoughts to read them in court, they may want to use a large font and a heavier weight type of paper. It's okay to show emotion. Personal details can be quite meaningful. It's also important to discuss with survivors that they are not responsible for the ultimate sentencing decision, whatever that ends up being. Victim advocates and victims' rights attorneys can provide support and guidance to survivors throughout the criminal justice process. And if a rights violation occurs, victims' rights attorneys can file motions and otherwise litigate on behalf of a survivor to ensure that their rights are enforced. If a victim believes their rights have been violated in the context of victim impact statements, victims' rights attorneys can use the following checklist to assist in preparing for litigation. Identify the victim's rights that have been violated. In addition to the specific right to give a victim impact statement, other rights may also be implicated, including the victim's right to notice of the sentencing proceeding or of their rights, the broader right to be heard, the right to be present, the right to restitution, and the right to be treated with fairness, dignity, and respect. Identify the remedy the victim seeks. Do they need to seek a stay or rescheduling of proceedings to allow them the opportunity to meaningfully exercise their rights? Do they need to seek to redo a sentencing proceeding that's already occurred in order to exercise their rights? Depending on the stage of the case and how a potential violation arises, different remedies may best meet a victim's needs. Assert all legal arguments necessary to further the survivor's position. Key arguments may also include an explicit section addressing victim standing, an argument that the sentence is illegal or invalid as a result of the rights violations, and a section addressing any double jeopardy concerns that may be asserted by the defendant. Adhere to any timing requirements and procedures for seeking enforcement of victims' rights in your jurisdiction. And depending on the posture of the case, be prepared to seek appellate review or further appellate review, and be familiar with the procedures and appellate vehicles that are available to challenge an adverse decision. Another critical aspect of victim impact statements is knowing where and how a victim statement may be used or accessed. Practitioners should research the law in their jurisdiction, including their jurisdiction's public records provisions, to identify whether and under what circumstances a victim's impact statement may be accessed and by whom. To that end, victims may want to be particularly aware of any private information they choose to include in a victim impact statement, and practitioners should research the availability of tools, such as sealing or redaction, that could help protect victims' rights to privacy and to protection. The right to provide a victim impact statement is often exercised in connection with sentencing proceedings, but survivors may also have the right to have their statement incorporated in some way in a pre-sentence report. It's important to keep in mind that pre-sentence reports are often written by an officer of the court based on what the victim submits, or based on their conversations with the victim, rather than incorporating materials written directly by a victim. For this reason and others, affording a victim the right to provide a statement for inclusion in a pre-sentence report does not satisfy a victim's broader right to be heard in connection with the sentencing proceedings. In addition, survivors may also have the right to give a victim impact statement in connection with parole, probation, and other proceedings related to changes in the custodial status of a convicted person. In a number of jurisdictions, victims are also guaranteed an explicit right to give a victim impact statement in connection with other proceedings, such as those related to pardon, commutation, or expungement. The victim's right to provide a victim impact statement is only one among many rights that come into play in connection with sentencing proceedings. In many cases, victims may also want to consider submitting a sentencing memorandum, which is a tool a victim's rights attorney can use to make legal arguments to the court about a defendant's sentence, including the victim's right to restitution. Additional publications and information expanding on victims' rights that relate to sentencing, including the right to give a victim impact statement, can be found on NCVLI's website.
Thank you for participating in this online experience, and we hope you enjoyed it. If you enjoyed this tool and are interested in other victims' rights tools, please visit NCVLI's other Toolkit resources for additional interactive learning exercises like this video in addition to other tools such as flashcards, tip sheets, and much more. One of NCVLI's key projects is the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA. Using its updated website, www.navra.org, NAVRA connects people committed to improving the justice system by providing the practical tools they need to protect, enforce, and advance victims' rights. NAVRA's tools include searchable databases of sample legal pleadings, legal memos, and key case summaries, as well as in-person and online trainings, partner listings, and the pro bono portal, which matches attorneys with crime victims in need of representation. And in addition to these resources and others available on our website, NCVLI is ready to assist by providing additional research and assistance that is tailored to your needs. Please visit www.ncvli.org and navigate to the online form by clicking the Professional Resources tab and then selecting Technical Assistance. Thank you for joining us.